This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we have a man bites dog story where GEICO bites some fraudsters expensively and why it is not appropriate or intelligent to try to defraud GEICO because it bites back. And being a proactive insurer defeated fraudulent durable medical equipment claims, sometimes called DME claims. Multiple GEICO companies sued Defendants ALP Supply, Inc., PV Supply, Inc., and Pal Vakula, alleging common law fraud and unjust enrichment claims. In Government Employees Insurance Company versus ALP Supply et al., the United States District Court for the Eastern District of New York on September 29, 2023, dealt with the effort of GEICO to obtain default judgments against healthcare providers and fraud perpetrators. The GEICO Plaintiffs moved the United States District Court for default judgment pursuant to Federal Rule of Civil Procedure 55B2. For the reasons set forth, the Magistrate Judge recommended that plaintiff's motion should be granted as to the common law fraud claims. The court further recommended that plaintiffs should be awarded damages. In sum, the allegations focus on the defendant's multifaceted scheme to defraud GEICO by falsely representing material information to collect benefits under New York's no-fault insurance laws. Healthcare service providers that do not comply with state or city licensing requirements are ineligible to collect no-fault benefits. Further, the relevant laws prohibit licensed providers from paying or accepting kickbacks for referrals. ALP and PV, both New York corporations based in Brooklyn, are retailers of durable medical equipment and OD. Vakula, a New York resident, owns and operates both businesses, but is not and has never been a licensed healthcare provider. From July 2019, Vakula used ALP and PV to submit and cause to be submitted to GEICO thousands of fraudulent no-fault insurance claims for medically unnecessary, illusory, and otherwise non-reimbursable DME and OD products. GEICO relied on this false information to process defendants' claims promptly pursuant to statutory and contractual obligations, resulting in payments of over $267,000. Defendants not only submitted claims to GEICO knowing that they included materially false information, but also hired law firms to pursue collection of the fraudulent claims from GEICO, which resulted in expensive and time-consuming litigation against GEICO if the charges were not promptly paid in full. GEICO sought to hold ALP and Vakula jointly and severally liable, and PV and Vakula jointly and severally liable. GEICO sufficiently alleged Vakula's joint and several liability as to PV and ALP, and accordingly to the complaint, Vakula owns and controls both PV and ALP and was directly involved in submitting fraudulent claims to GEICO through those entities. The alleged harm to GEICO is indivisible between Vakula as the owner and operator of each corporate defendant. Accordingly, the magistrate found that joint and several liability is appropriate as to ALP and Vakula and PV and Vakula. GEICO alleged that the defendants committed common law fraud. Under New York law, a plaintiff asserting a claim of common law fraud must plausibly allege 1. A material misrepresentation or omission of fact, 2. Made by the defendant with knowledge of its falsity, 3. With an intent to defraud, 4. Reasonable reliance on the part of the plaintiff, and 5. Resulting damage to the plaintiff. GEICO also sought a declaratory judgment and the court noted that GEICO established that an actual controversy existed, and that a declaratory judgment would afford specific and conclusive relief as to pending claims with respect to all defendants. GEICO alleged that ALP and PV have pending bills submitted to GEICO that GEICO has no obligation to pay. Additionally, GEICO submitted documentation of pending collections actions that ALP and PV are actively prosecuting against GEICO in New York State courts. GEICO has provided a list of the actions, including the amounts involved, the claims numbers, and the status of each claim. In sum, plaintiffs GEICO established liability on their common law fraud claims. The magistrate judge therefore recommended: 1. A default judgment should be entered against the defendants for common law fraud. 2. Plaintiffs should be awarded compensatory damages in the amount of $112,201.74 jointly and severally against ALP Supply, Inc. and Vakula, and B, $188,799.94 jointly and severally against PV Supply, Inc. and Vakula, with prejudgment interest to accrue at an annual rate of 9% until entry of judgment, with revised calculations to be provided to the court to determine the specific amount due. And 3, a declaratory judgment should be entered that plaintiffs have no obligation to pay any claims submitted by ALP Supply, Inc. and PV Supply, Inc. In my opinion, GEICO clearly seems to have given up on departments of insurance and prosecutors to defeat insurance fraud by proactively suing the fraudsters and taking the profit out of the crime of insurance fraud. Its success in this case and others should be emulated by the insurance industry, who sit back and allow fraudsters to profit from their claims. A terrible and useless act. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe at the blog, and it is free. Please, if you found this video to be of interest, tell your friends and colleagues about the blog and the videos and let them subscribe. The videos are also available on rumble.com and youtube.com, and I'd appreciate it if you view them there, that you click on the thumbs up button on Rumble and the YouTube button, like button on YouTube, and also subscribe to the YouTube and Rumble videos. This video is free to all, and the list remains with me alone. And if you're interested in more details and more information about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my Substack publications or my locals community. Thank you for your attention.